First of all, I'd like to acknowledge all the messages coming through on the chat. Thank you very much, Talofa lava to everyone, and welcome to this webinar. Thank you for taking the time out of your busy days to attend this webinar presented by PILON, our Pacific Islands Law Office work. This webinar is brought to you by our Sexual and Gender-Based Violence Working Group. My name is Hellene Wallwork. I am the Interim Attorney General for Samoa. Some of you may already know also that I am currently the chair of the working group, and I'm honored to chair this webinar today. The title of our webinar today is the Special Measures Series on Lessons Learned. This is the first in a series of webinars which focuses on the use of special measures in cases involving sexual and gender-based violence. As we know, sexual and gender-based violence is a global pandemic, global epidemic, which our Pacific region is not immune from. The social costs of this epidemic not only harm the victim and their family, but have wide-ranging impacts on our societies at large. The Pacific Islands Forum's Wallwork Declaration on Regional Security has identified the levels of violence as a security concern for our region. To address human security concerns, the Wallwork Declaration Action Plan includes eradicating violence against women as a priority measure. These efforts to eradicate violence against women have faced new obstacles during the COVID-19 pandemic. Currently, while many countries in our region are struggling with the health and economic impacts of the COVID pandemic, there has been a parallel increase in the rates of sexual violence. This shadow pandemic has presented challenges for police, prosecutors, women's support services, courts, victim support services, and healthcare officials, both because of their resources have been occupied by the pandemic, and also because the lockdown measures have largely prevented them from providing in-person services. However, during this time, we have also seen courts increase their use of technology to enable evidence to be taken from vulnerable witnesses remotely. We have also seen other innovations, including women's support services, adapting to this new environment by seeking to be declared as essential workers. Despite the increase in the rates of sexual and gender-based violence, reporting rates remain low and conviction rates are even lower. PILON is collaborating with partner agencies who share our understanding that addressing this issue requires a coordinated approach. I am delighted to see representatives from many of those agencies here today on our webinar series. I am pleased to announce that as chair of this working group, I have also recently accepted an invitation to sit on the Pacific Islands Chiefs of Police Board of Management as PILON's representative, to oversee the implementation of the PICP's Gender and Family Harm Implementation Strategy. We will be working together to ensure a seamless transition through the justice system from the time a person first engages with the police. These efforts seek to overcome some of the barriers that prevent appropriate cases from making it to court. The working group recognizes that courtroom and the court process can be intimidating. It can make witnesses feel uncomfortable giving their evidence. Witnesses can sometimes freeze, forget to mention important details of their evidence, or may not even want to proceed with giving evidence. This can impact on the court's ability to form a view about the witness's evidence and also assessing the witness's credibility, which can impact on it doing justice. The giving of incomplete evidence or not being willing to give evidence can be a barrier to achieving justice. It is in this context that the working group developed the model provisions for supporting vulnerable witnesses in cases involving sexual and gender-based violence. This model establishes best practice implementation of special measures. Special measures are practical tools designed to support witnesses to give their full evidence to the best of their ability. They may relate to how evidence is given. For example, in a closed court via CCTV or through a translator, or how the courtroom is set up, such as the use of screens and seating arrangements to reduce stress. Other examples include the removal of wigs and robes for the jurisdictions that still have them, the rendering inadmissible evidence of sexual reputation, and directions given to the fact finder, such as the fact that many witnesses may take some time to make a report to police. To further our discussions about how countries can implement social measures in their jurisdictions, we are honored to be joined by two very experienced prosecutors today who will share their expertise with us. These presentations today will demonstrate that there are many different ways special measures can be implemented. Judges may use inherent jurisdiction to provide for the measures, or they may be enshrined in the Constitution or other legislation. Our first presenter today is Principal State Prosecutor, Ms. Juleen Fatiaki, the Manager of Sexual Crimes Division within the Fijian ODPP. Our second presenter is from here in Samoa, our Acting Assistant Attorney General in charge of our criminal team, Ms. Iliganoa Atoa. After Ms. Juleen Fatiaki and Ms. Iliganoa Atoa present, we will then pause to check the progress of our graphic recorder, Ms. Jessamy Hughes. Jessamy will be creating a live visual presentation of our speakers' presentations, which will be emailed to all our participants today. And finally, I will facilitate a question and answer session. We encourage you all to ask questions and share positive experiences of using special measures, as well as any challenges you may be facing. So I'm very much looking forward to our presentations, and I hope you are too. And on that note, please let me now invite Ms. Juleen Fatiaki from the Fiji Office of Public Prosecutions to share her presentations with us. Juleen, you have the floor.
Good morning, the Honourable Attorney General, my fellow panelists, ladies and gentlemen, good morning from Suva. Firstly, on behalf of the DPP, Christopher Pride, I wish to convey my thanks to the organisers for the invitation to speak to you all this morning. By way of a little bit of a background, the division which I currently manage, which is the Sexual Crimes Division, we are a specialist unit within the ODPP, and we are responsible essentially for prosecuting crimes of sexual and gender-based violence, child sexual abuse, and other crimes where children are victims. I thought that before talking about some of our experiences in using special measures, I would briefly speak about how we here at the ODPP go about dealing with vulnerable witnesses, in the hope that it will better set the context of how it is we come to a position to apply for special measures in any given case. In our line of work, as I am sure, as with most other prosecutors in the region, we only come into contact with witnesses after a police complaint has been lodged and after an accused person has been charged and produced in court with a criminal offence. It is the expectation of our office that when dealing with a case involving a vulnerable witness, the prosecutor is to introduce him or herself to the witness as soon as practicable. And usually this is after having received the file, having assessed the evidence on the file, and then the DPP having sanctioned the file and the charges filed in court. If we are dealing with a child, our prosecutors, before meeting the child, will meet with the child's guardian, or a counsellor if one has been assigned, or the investigating officer. And the purpose of this meeting really is to allow the prosecutor an opportunity to better understand the specific needs and the personal circumstances of the child, whether it be an intellectual or physical or mental disability, and so forth. From experience, this meeting has truly helped me as a prosecutor to help the witness feel at ease when I meet him or her for the first time, because by then I would have brought myself up to speed and I would have prepared myself in terms of how best I should approach this witness, bearing in mind their special circumstances. At the ODPP, we usually encourage counseling. We do not provide this service in-house, and so we would refer vulnerable witnesses to organizations that do. In Fiji, we work very closely with the Fiji Women's Crisis Center and other organizations that provide these services. And in my experience, the use of counselors cannot be overstated. They play such an important role in terms of providing support to these witnesses, support which we as prosecutors cannot give because of the nature of our role. The Fiji Women's Crisis Center, in fact, also provides support to witnesses years after a trial has been completed. And their support really is just so valuable. We also refer witnesses, specifically children, to social welfare. That hasn't been done by the investigation officers. Now, these initial meetings that we have with the witness, really it is for the purpose of rapport building, to build a foundation of familiarity, a foundation of trust, which for obvious reasons is so important. Having established that contact with the witness, our prosecutors are then expected to have at least a pre-testimony meeting with the witness. And this is usually done after a trial date has been set. And it's during these meetings that the prosecutor will explain the court process, will refresh the witness's memory if need be, and will answer any questions that the witness may have about giving evidence in court. And these pre-testimony meetings, these interviews, it really is in the interest of the well-being of the victim, the witness, to try and help them in reducing the stress and anxiety they may have about testifying, because we know it is a very daunting process. It is also during these meetings that a prosecutor will discuss with the witness the special measures which are available. Another aspect of the pre-meeting or interview phase is the courtroom familiarization visit for the witness. And this is also such an important tool because it allows the witness an opportunity to see for him or herself the place in which they will be giving evidence, now whether that be a courtroom or whether it's going to be another room, depending on the nature of the special measure. In Fiji, we have a codified list of special measures which one can apply for the purposes of facilitating the taking of a vulnerable witness's evidence. And this is provided for in our Criminal Procedure Act. This came into force in 2010. It is probably worth noting at this point that this act, prior to this act being passed, in fact, the courts in Fiji were already making allowances for the use of special measures in trials involving children. In fact, the first ruling allowing for such measures was delivered as far back as 2005. Now, our Criminal Procedure Act does not define a vulnerable witness. But from our experiences before the courts, children are usually readily accepted as a vulnerable witness. Our difficulties seem to arise when we're dealing with adult witnesses. Having said that, I have prosecuted cases where we have been able to persuade the court that an adult woman, by virtue of the nature of the offense which she is going to testify in, be it a sexual offense or an offense involving violence, can be considered vulnerable for the purposes of the application of the measures. Some courts have accepted this and some haven't. So essentially, whether or not the measures sought will be granted comes down to a case-by-case basis. And the court exercises their discretion in weighing the need to minimize the stress on the victim or the witness, while at the same time ensuring a fair trial for the accused. So it is a result of this rapport building sessions, these pre-trial meetings with the vulnerable witness, that we are then best placed to know and understand what special measures are required for a particular witness. And from experience, I can't overstate this. It is important that the vulnerable witness be told what measures are available and what would be some of the advantages and disadvantages of any particular measure. It is then that they can make an informed decision about what they feel they would be most comfortable with. Their views matter, whether it is a child or an adult. their views matter, because at the end of the day, they are the ones who these measures were made for. These measures, the application for these measures, are usually made here in Fiji before a trial takes place, so at the pre-trial stage. But of course, there may be instances where these applications will be made on the trial date itself. There's no time limitation, essentially. And in Fiji, we've utilized almost all, not all, but almost all of these measures. Some of the more common ones, and I'm sure some of you would have used, name suppression applications, closed court applications, child support person to be present during the taking of the evidence. And for this one in particular, we find that it's very useful with children, and especially with children who want to give evidence in court. And so what we do is we try and ensure that the support person is either a family member or counselor, but essentially not someone who is going to give evidence in the case. And their main purpose really is to be there and just to provide some form of comfort, a feeling of safety for the witness who's testifying. And it has been very effective in my experience. As the Honorable Attorney General had mentioned, the derobing of counsels and the judge, this is something we often use because here in Fiji, as you can see behind me, my wig is there, we still have to robe up. So we would generally take this off and the judge will come down from his or her seat and join the rest of us seated while the witness will give their evidence. The use of a screen also has become quite common here in Fiji. And, we had a case actually a few years ago, and it involved a 3-year-old child. And the prosecutor had made an application for the child's evidence to be taken in advance of the trial, so essentially pulling it forward. And back then we had assessors, we no longer have them. And because there were no available trial dates, what the trial judge did was he allowed the application. So we took the child's evidence, my colleague took the child's evidence in the presence of the judge, in the presence of the defense counsel and the accused, and that was video recorded, so it was a pre-recorded testimony. The child was also cross-examined, and then later on, when the trial actually started, that video recording was played for the purposes of the trial for the assessors. So that was a very effective means of ensuring that these cases were dealt with as quickly as possible. In Fiji, we also quite often use the child room. So we take the evidence by way of Skype, where the child will be within the court premises, but in a different room, a child-friendly room. And we find that this is also a very good means of taking their evidence to reduce the stress that they would otherwise encounter should they be in court. I think what I can say in terms of what I've learned about using special measures, and the main takeaway for me is that it's not one size fits all. Every case, every witness is different, and they will require different measures. I'll give you an example. A few weeks ago, another colleague of mine conducted a trial involving an intellectually disabled child. And this child, for the purposes of her evidence, in fact, had undergone a psychiatric analysis, and a report was prepared by the psychiatrist. Part of his recommendation was for the child to give her evidence in another room, so not in the courtroom. Now, when they went for the court familiarization visit, it became apparent to the prosecutor that, in fact, the child seemed more comfortable giving evidence in the courtroom from behind a screen as opposed to the child-friendly room. So the prosecutor asked her, and she confirmed she wanted to be in the courtroom. She wanted to be included, but of course, other measures were applied, so the use of the screen. And I was curious about what led the psychiatrist to make that assessment, that recommendation. And so I had an opportunity to speak to him about something else, and I asked him. And he was humble enough to admit that he just assumed that the use of a separate room where a child is not in the same room as the perpetrator would be better off for the child. And so essentially, he didn't ask what the child would have preferred. And so, as I say, one size does not fit all. It's a case-by-case basis, and it's so important that we ask those who are actually going to use these measures what their preference would be. Now, on paper, these measures are great. When applied and utilized correctly, in my experience, they have done wonders for ensuring that vulnerable witnesses also have equal access to justice. But all of this, all these steps we take prior to the trial in terms of rapport building, counseling, preparation of the witnesses, the mini pre-trial hearings to determine special measures that will be used, all of this really will be in vain if we finally get to the actual trial and those of us who are participating in the trial further traumatize these witnesses in the manner in which we conduct our respective roles. So I guess my question to my colleagues across the region is this: are we doing enough as advocates, as judicial officers, as participants in the criminal justice system to ensure that these vulnerable witnesses are going through the process safely and we are not further traumatizing them? In all honesty, I didn't realize, or I didn't understand up until a few years ago, why it was important for me to know what impact these crimes have on children, on women. I am now so convinced that in order for us to truly discharge our duties as officers of the court in the conduct of these cases, we must adopt a trauma-informed approach. We must understand the impact of these crimes so that when we are conducting these cases, we have a real understanding, a real grasp that if we do not get it right, we will aggravate the harm which has already been caused. I have seen this happen firsthand. I prosecuted a case once in the Western Division about 6 or 7 years ago, and it involved a young child who had been raped by her stepfather for many years. And she gave evidence from behind the screen. During the trial, the defense counsel insisted on a doc identification. The trial judge insisted on doc identification despite our objections. And can you imagine, I mean, what was the purpose for it? This is her stepfather, it is someone who is known to her. But the objections were overruled and we were told to remove the screen. And when I told this child that we would have to remove the screen, she went hysterical. We had to adjourn the case, and we came back, we had to remove the screen. And of course, she pointed him out through tears. The child left the courthouse. We got the conviction, but she's no longer here with us today because she manifested such severe traumatic behavior that her mother, a few months after the trial, couldn't tolerate it anymore, and she beat her to death. In fact, just the other week, we had a trial involving a case of rape here in Suva. And the defense counsel, in cross-examining the witness, asked the witness to reenact in court how it was that she screamed when she said she was being raped. Can you imagine? And it didn't stop there. The learned trial judge then asked the witness to repeat it. And my office will also accept the blame for some of this because we did not object. And so the witness had to go through all of that, essentially being raped again for all to see. I think what I'm trying to get at is we need to do better. we all as participants in the criminal justice system. The Honorable Attorney General pointed out that these cases are increasing. It's an epidemic. And if it's an epidemic, what that means is those of us who are in the criminal justice system are going to come into contact with more and more of these children or these witnesses. So we have to do better. In our office, we've had these conversations. We continue to have these conversations. We are committed to doing better, on handling these cases better. We are committed to achieving best evidence and ensuring child-friendly approaches in the way we prosecute. Under the DPP's guidance, we continue to work closely with counselors. We hold trainings for our staff, and prior to the world of COVID, we brought in experts to train us in advocacy in child cases. For the first time, we presented to the court a report on the mental health outcomes of these crimes on children and women. And that was part of the sentencing process in the trial we did under the leadership of our former ADPP, Dr. Iliganoa. And in that case, we obtained the first life sentence for Fiji and the Pacific for an offense of rape. We are trying with urgency to get it right, because we know what it means to get it wrong. I would be particularly interested to know how my colleagues across the region are faring in the conduct of these cases, and whether they too have realized the importance of a trauma-informed approach to this work. So I guess the question for us, or that I'd like to pose really, is this: what can we all do about it? I propose specialized training. In many jurisdictions around the world, lawyers and judicial officers are mandated to attend trainings on how to deal with vulnerable witnesses before they can go near any of these cases. They must be certified, and there's good reason for it. I know that the PILON Secretariat has provided advocacy training for lawyers around the Pacific. So my suggestion is, what about considering offering specialized training for our advocates who want to practice or who have to practice in this area? You know, there's so much more that I could say about this area because I'm very passionate about it. And so I'm very grateful for having been given the opportunity to speak a little bit about, you know, what we're doing here in Fiji in terms of the application of these measures and you know, the real problems that we see that are unfolding, and maybe offering some solutions to some of these problems. And I really look forward to the discussions that will be held after this. As I said, I can go on and on, but I'm conscious of the time. So, you know, thank you very much for listening to me, and I look forward to engaging into discussions later on.
Thank you so much, Ms. Fatiaki, for such an interesting and informative presentation. Your passion definitely has shown through in your presentation. Now I want to invite our Acting Assistant Attorney General, Ms. Iliganoa Atoa, to also speak on the use of special measures here in Samoa. Thank you, Ili. You have the floor.
Thank you, Madam Attorney General. Talofa to all our participants. We have a full house here from the Samoa Attorney General's office. I would like to say good morning, good afternoon, and talofa lava to all our delegates from each member country, and to the PILON working group for organizing such a very well organized conference for us all today, and most especially to Madam Chair. As much as I would like to say I'm excited to participate in this webinar, in which I am, of course, I am now mostly worried about giving a presentation on my first appearance. Anyhow, thank you very much, Fiji, for leading the way for us. That was a very well informative presentation. Firstly, thank you to the Secretariat Support Group for allowing Samoa to present today and the opportunity given to share some experience from cases that we have dealt with in the Samoa jurisdiction, particularly about special measures involving vulnerable victims. I tried my best to find time to choose an interesting case in particular to share with you all today, but I've discovered that our cases may not be as interesting as the other Pacific Island regions. So today I also look forward to what I'm about to present to you all. My name is a long Samoan name, but you can refer to me as Ili. I'm Ili. I'm currently overlooking the Criminal Prosecution Division, which includes various areas of criminal cases ranging from Supreme Court to youth, district, and specialized courts. So today I want to share a bit about special measures in our courts. In terms of successful measures, we practice and is widely accepted as a practice in our courts is by way of alternative ways of giving evidence. So that's provided for in our Evidence Act, where the witness can give evidence while in the courtroom, but unable to see the defendant or some other specified persons. There is also another option of placing the victim outside of the courtroom setting, which by then we would use the means of electronic communications. And lastly, pursuant to our Evidence Act, we can use video recording prior to the hearing. Now, specifically, what is most commonly used and applied and acceptable in our courts as a normal measure now is what we call the use of screens. So in Samoa, it's basically just creating a partition to block the victim from being able to see who is in the courtroom, except for the judge, of course. So this measure enables the victim to feel more comfortable and secure to give her testimony without being seen by anybody, and most especially without her seeing the defendant. So that's in courtroom setting, just creating partitions to block her out. That's our most effective special measure, which is commonly used in Samoa, and the judges have accepted it as a way of giving evidence in all of our cases where we have vulnerable victims. This is the first special measure option we look at, and it has been proven effectively. How we apply it and how it works is, well, upon interviewing the victims or briefing them or getting to know them in terms of interviewing them before the hearing, it's from there that the prosecutor decides what is the appropriate special measure that we should apply for this particular victim, which is interesting to know the Fijian approach where the victim is told of the special measures. Our point of view is that most victims who are vulnerable are young at age, which are, let's say, from 5 years old up to 11 years old. And that's when we decide, well, from getting to know the victim, it's where we decide, okay, this victim would be more comfortable in a situation where we have to block the defendant out from seeing, or the victim from the view of the defendant. So after we make that decision, we then, prosecution makes the application to the court in ample time so that any objections can be raised by defense way before the trial. But in Samoa, they usually never object because, of course, we all, even defense counsels, want to make the victim speak about the offending and to hear their testimony. So they're more helpful in those terms of allowing special measures to apply so that we are able to hear the testimony. Our courts as well, the judges become very helpful in that sense. So there's never an application where the judges or the judiciary has objected to us applying special measures. It always goes through. And I guess that's why I say it's effective as a first means of special measure. It's because of how we commonly use it. So that's how it works. Now I will talk about the other method or special measure which is provided for in our legislation, but it's hardly used. It's almost similar to being in court, except that the victim gives evidence from another room. But unfortunately for Samoa, we don't have a child-friendly room. We only have an assessor room behind our actual court sitting room. So that's an option that's available, but it's hardly used. And I say this because it requires a lot of technical support, from the Ministry of Justice to assist with setting up the microphone, setting up the screen, the equipment and whatnot. So the problem, of course, is that in the islands, as we like to say, we have limited resources. Although it's available, it's not preferred because it's not convenient due to the time, and setting up of it just takes more work than the first measure, as I've mentioned. So it's mostly used in special circumstances where the victim is overseas. That's when it automatically comes into effect. And then we apply, the victim is overseas, of course, that's the only means of giving evidence is through video link. So then that enables this part of our Evidence Act to come into effect. And lastly, another measure that is available but has not been fully utilized yet is the use of video recording made prior to the trial. Our Evidence Act provides the use of a video record made before the hearing. That has not been explored yet, but we are looking at it and utilizing it as we have to deal with the rising issues with child victims and vulnerable victims at this stage. So I would be interested to know if this way of giving evidence is effective in other jurisdictions and how to go about doing it, so that we can also look into it and apply it in our jurisdiction. Now, those are the most common and available special methods in Samoa. But giving evidence in court generally by a vulnerable victim comes with a lot of issues that happens outside of the courtroom as opposed to the issues arising inside the courtroom. And it's from surrounding circumstances of the victim themselves and where they stay. For example, we had a recent case where the accused is the stepfather of the victim, who was 15 years old at the time, married to her mother, of course. And he was charged with rape, and the mother laid the complaint to police. Charges were filed, hearing was set. We called in the victim for interviewing, and what happened was that we had discovered the defendant now lives with the mother and the victim in the same household. So it turned out the victim does not want to give evidence anymore. The mother is now insisting to withdraw the charges, which she filed a complaint for. And then we have the defendant living with them in the same household. So of course there are measures to take to overcome what is now happening. But then it comes down to this. We take this victim to court, let her say her evidence, get our conviction, but at the end of the day, they go back to the same household and they live in it. So how are we to provide special measures to support this victim with having to live with the defendant? And now we're also faced with the issue of we can't get her to give evidence because now the mother and the victim no longer want to give evidence, as if nothing happened. So that's an issue we would like to hear from the other jurisdiction as to how we could overcome that situation when it does arise again. And interestingly, another case scenario, which is an actual case, defendant is charged with 1 count of rape, 2 counts of sexual connection. He is the uncle of the victim. And of course, the mother lays the complaint to police. Everything is well. We interview the victim. She says everything that happened. We went to court for trial. Examination in chief went well. Everything came out. All the evidence was laid out clearly. And interestingly, the twist was the panel of assessor, of course, and judge went on a luncheon break. This was before cross-examining this victim. And during the luncheon break, the mother had persuaded and influenced the victim to change her evidence, recant her evidence, and say nothing happened. The defendant did not do anything. This was before cross-examination. So court resumed. The victim came in, was cross-examined, and changed the whole evidence. Contradicts everything she said in the examination in chief. And luckily for us, we had a witness who was the investigating officer that was outside with the mother and the victim during the luncheon break. And she heard the mother trying to change the evidence of the victim. So that was, of course, when it came to our attention, we were fortunate that there was a witness who would now justify as to why there's a sudden change in evidence. And then we had to file an application for mistrial because of what we had discovered. So the trial could no longer proceed. The judge ruled for a mistrial, and now the hearing has come up again and it's scheduled for retrial. So we're also preparing that again. And of course, the problem now we're faced with is, will the victim go back to the evidence in chief and support that, or will she come back and still maintain what has happened with the change of evidence? So those are some of the interesting situations where we're saying special measures are available in court and it can be applied, but there's also the real issue of the surrounding circumstances in the background of where the victim lives and what she is encountering while we are waiting for the trial to commence. So those are some of the things we brought up and thought it'd be interesting to hear and learn from other jurisdictions and share some point of view from it. So to assist our small island. So I think that's all I wanted to share. Untitled Chapter, Madam Chair, as well as the Secretariat group for allowing Samoa to take part in this, as well as present. I hope the information provided was of some use to other jurisdictions as well. Thank you.
Thank you very much, Ms. Atoa, for that fantastic presentation. I appreciated the practical examples that you shared from your experience in recent cases. I believe they really illustrated the benefits of using special measures, but we can also take away from this presentation the highlight of the obstacles being created with our limited resources available to us as prosecutors in the small islands, as well as the harsh realities of the family circumstances of our vulnerable witnesses, as also highlighted by Ms. Fatiaki. These are the realities that our victims return to after the trials of and challenges of being in a court hearing for these prosecution matters. So thank you very much again for that, Ms. Atoa. At this point, I now want to check with our graphic recorder, Jessamine, to see how her graphic illustrations are going. Wow, that looks really cool, Jessamine. Thank you so much. Isn't that wonderful what you've recorded? I think we're kind of running out of time now, and it's time we have to wrap it up. Thank you very much to everyone who took time out to take part in our webinar today. A special thank you to our presenters. I know Juleen has left already, but we couldn't express enough appreciation for the time she took to prepare her excellent presentation for us today. Special thank you also to Ms. Ili from our office here in Samoa for, I know as some of you may be aware, we're very short-staffed, and I'm really grateful that Ili took on the responsibility at short notice to prepare this presentation, and very much appreciate that, Ili, and for sharing your experiences with us today. As for all our participants out there, a recording of this webinar will be circulated to everyone, along with the finalized posters from our very cool graphic recorder, Jessamine. We'll be sending out a very short survey as well after this, and we'll be really grateful if everyone could use it to provide feedback. This helps PILON and the working groups to improve our training sessions in the future. If you would like further information or assistance with the implementation of special measures in your country, please provide your contact details in the survey. These requests may be considered by the Australian Attorney General's Department. Alternatively, you can also email the PILON Secretariat, and we'll ensure you get the information you need. On that note, I wish you all a very happy and safe afternoon and weekend, with Anzac Day ahead on Monday after our weekend. Thank you very much also to our colleagues from the Australian Attorney General's Department for the support provided in this webinar. So keep an eye out for future webinars on save the dates that will be emailed from our PILON Secretariat. So on that note, it's to Fasoi Fu from me. Thank you all and goodbye.